Let's come back home to Texas. So the final example that we're going to use for asset protection for our clients is series limited liability companies. All right. So a series LLC, basically it allows your client to hold assets in different subsidiaries or series, if you will. And basically the assets in one series and one subsidiary are protected against the liabilities of the assets in the other series or cells. So we're going to look at a chart in a second here. But basically, this is a powerful tool that you can use for your clients to shield your client's assets against the liabilities of the different series. So one of the, as you can see here on the chart, we have a sample series LLC where the parent is in the middle. The parent owns the subsidiaries on the right. So here in this example, I created 4 subsidiary series. I love using this for clients that have real estate. This works great for if you have clients that have several commercial or rental properties. We can title a different rental property in a different subsidiary. So here in this example, let's say your client has 4 rental homes with 4 different tenants. That's great. We can create 4 series subsidiaries on the right. You can see there's series A, B, C, and D. Each one has a rental property titled in each one. And let's say there's a lawsuit. Let's say the tenant in rental property A, there's an accident and they sue the landlord for negligence or breach of contract or whatever. Well, guess what? The only asset they can go after is the rental property in series A, because that's where the tenant is. They're in series A, and they can't go after the properties in series B, C, or D. So that's one of the great things that we can use the series LLC for, is if your client has multiple rental properties, we can protect the rental properties from each other's liabilities. The flip side, and I've seen this time and time again with my clients, we have a client with, again, same example, 4 rental homes in one LLC, a plain vanilla LLC. And here comes a lawsuit from one of the tenants in one of the rental homes. Well, guess what? If they have the 4 rental homes in one plain vanilla LLC, and there's a lawsuit on one of those rental homes, all 4 rental homes are now at risk if they have them in one plain vanilla LLC, one entity. So and again, I've seen this happen to my clients time and time again. They have multiple properties in one entity. Here comes a lawsuit. All the properties are at risk. Let me give you an example. I have a very wealthy client from Mexico that invested in some apartments in South San Antonio. They invested $10 million to build this apartment complex. In addition to the apartment complex, they had, I think, like 3 or 4 rental properties. And the rental properties combined were about $1 million. And then, of course, the apartment complex was $10 million. And something happened. I don't remember exactly what happened, but the apartment complex got into a lawsuit for breach of contract with a builder that was building them. And guess what? The apartment and they had everything in one LLC, because that's just the way they had it. So you have 4 rental homes plus the apartment complex all sucked into this lawsuit because the apartment complex got sued. Client came to me after the fact, after the lawsuit, and said, "Hey, Ivan, can you please help us? We want to create a new LLC and take the rental homes out of this entity because they're involved with the lawsuit with the apartments." And I said, "I'm sorry, sir, I can't help you. That will be considered a fraudulent transfer." Remember, we talked about fraudulent transfers earlier. This is a clear example of a fraudulent transfer. So I told them, as soon as your lawsuit is over, after you settle with them or get a judgment or whatever, when you're finished with the lawsuit, then and only then can we take those rental homes out of the LLC and create a new entity. And in fact, I proposed a series LLC for them, but the caveat there was we can't do it until the lawsuit is over, because that will be considered a fraudulent transfer. So again, we need to use these with wisdom. Can't do it in the middle of a lawsuit. So going back to the series LLC features, every individual series is statutorily empowered to basically act like an entity, conduct business, have its own bank accounts. Each subsidiary can hold its own property, and again, it insulates it from the liabilities of the other properties and the other entities. All right. Now, to create a series LLC, all you have to do is file the certificate of formation with the Secretary of State. Previously, to create the subsidiary series, you had to file an assumed name certificate with the county, but the law changed a couple of years ago, and now we just have to file an assumed name certificate with the Secretary of State, and that's how we create the subsidiary cells that you see there on the right. If you have an existing LLC and you want to convert it into a series LLC, all you have to do is file a restated certificate with the Secretary of State, and the restated certificate will have the language of the series LLC, and that's how you can convert an existing LLC into a series LLC. You file an assumed name certificate with the Secretary of State. If you're interested in doing this, I've done this several times for my clients. I'd be more than happy to share a template with you. So furthermore, with the series LLC, it's not just a matter of creating a subsidiary. So as estate planning attorneys, one of the recommended things to do is we like to create trusts to own the membership interests. Again, so what happens to the client if in death or disability? Well, if they own the LLC, we don't want to have to go to probate court. So typically we have different types of trusts that will own the membership interests. So here in this example, not just for estate and succession planning, but for additional asset protection planning, we can create a domestic asset protection trust to be a non-voting member, or a Texas irrevocable trust. If your client, the trust maker, does not intend to be the beneficiary, then we can use Texas and create an irrevocable trust for other family members. And in addition, we can, if you want a really tight asset protection structure here, we can create a management trust that will be the managing entity of the series LLC. We can make that management trust an offshore trust. So again, this is a very powerful structure that we can use for asset protection purposes, that we can use for our clients. And again, you don't have to go offshore. I'm just using this as an example, but if you have a client that has a multi-million-dollar investment, well, it's our job as attorneys to recommend the strongest asset protection structure that we can for our clients. Another issue is charging orders. So here in Texas, the exclusive remedy, if your client owns an LLC, if your client has membership interest in an LLC, and they get a judgment against them for something that they did outside of the LLC, let's say they got into a business dispute and they got sued, or a different type of lawsuit, and that creditor wants to invade your client's membership interest in an LLC. Well, in Texas, all they can do is get a charging order, which is basically a judgment lien against future distributions. Okay, so the charging order remedy for the LLC is a powerful asset protection tool that we can use for our clients to shield against their personal liabilities so they don't invade their LLC's assets. The same cannot be said for corporation, which is something that personally I highly disfavor using corporations for estate planning and asset protection, because a corporation, if your client gets a judgment against them for something they did outside of the company, well, guess what? The corporate shares can be taken to satisfy a judgment. But if your client owns an LLC, well, the charging order is the exclusive remedy. So again, this is another powerful tool for using LLCs for asset protection purposes, is for the charging order remedy. And furthermore, if we go back to the structure and we have a management trust that's offshore, and here comes the Texas judgment saying, hey, we're going to slap a charging order against your client's interest. Well, guess what? If the manager is an offshore entity, they're not going to be able to enforce that charging order because the offshore jurisdiction does not recognize a Texas judgment. So again, this is another powerful tool that we can use in conjunction with the charging order remedy to really help isolate our clients and protect our clients' interests. Caveats piercing the corporate veil. We need to be careful that when you create the series LLC, that your client actually respects the series LLC structure and integrity. So what that means is, again, using the example of the 4 rental properties, we need to make sure that each of the rental properties listed here, A, B, C, and D, that they all have a lease in the name of the subsidiary. We need to make sure that each one has a bank account that's collecting rent. We need to make sure that each subsidiary series has its own accounting, it's keeping its own books. Because if you treat this as one big entity and your client doesn't respect the separation of different subsidiary series cells, well, Now we have, piercing the corporate veil issues and say, no, you're just using this as a fraud. Let's invade and take the LLC assets. Or if you're using the LLC as a personal bank account, a lot of expenses that are not business related. Again, that's where piercing the corporate veil comes in, and they can, seize your client's assets for a judgment that they did outside of the LLC. So again, these entities need to be treated as separate business entities with their own accounting, their own contracts and stuff like that, because we don't want a court to pierce these entities that we created.